Okay, the big one for today, major theme. All right.
Psychological hazard.
Yeah, I want to talk about this, and Nina and I, it's interesting. I just did this presentation for mates in construction. Hi to those guys, by the way, and also to Debbie, who retired, who's not from there. G'day, Debbie, I should say that.
Yes, I do.
What we've always talked about is Burke and Son Corpin cases, where you look at the nature in the gradual decompensating behaviour of a person as a result of psychological hazards.
Yeah, where there's obvious signs that something's
and
wrong.
so you've got a Burke and Son Corp that said if a reasonable person can observe it under the obligations to monitor health, to try and performance manage the person would be wrong. Kubat says, yeah, it has to be a reasonable person, all that sort of stuff.
Yep.
But what we're seeing here is in the common law, which will flow back into safety law, the High Court made a decision in Komozarevs that basically said this: if your workplace is inherently dangerous, then you have a positive duty to intervene, not to wait what they called sentinel symptoms.
Yeah.
Now, Komozarev was a case of a woman who worked in a sexual assault unit as a lawyer.
The DPP.
DPP.
Yeah.
And obviously was exposed to some fairly horrific stuff and became unwell. But nobody noticed that at the time. And what Komozarev said is it doesn't matter, you don't notice it. You place a person, you identify they're in a hazardous environment. You know it's a high-risk environment.
Yeah.
Then the controls are a positive duty to ensure the person is safe, to rotate them, to check in on the person regularly, do all those sort of things. And then we had Bursey, which is the Victorian Court of Appeal case, and maybe you can have a quick chat about it.
Yeah, so that involved a teacher who hurt himself because his workload increased from 22 to 25 students. His stress and anxiety increased because of the increase in noise. And they said in that case, although it wasn't a breach of the proactive duty to do with primary breaches, they did fail to say that because there wasn't any signs, there was nothing they should have done, which isn't correct at all.
Yeah, so the county court dismissed it on the basis of, look, nothing to see here. How could they intervene? And what the Court of Appeal said is, look, you're not going to win because you're not that damaged. It's the short answer, and there's no causation. But what the Court of Appeal did do is they gave real clarity around what Komezarov for the High Court case means. And so they looked at an example and said, look, and this shows you what an inherently dangerous workplace can be. It doesn't have to be something as challenging as working in a sexual assault unit. It can be working in a school under intense pressures and changes in pressures. And the thing is, safety law says when you change the manner in which someone's work, you must consult and reassess the risk. Not dealt with because common law lawyers don't really understand safety, and the court wasn't really addressed in that, but it's very significant for safety law.
Yeah, it doesn't make sense to me why it's not well known, because if you think about it, Andrew, if there is a physical hazard, if we have to do a risk assessment for anything, we always consider whether there is a hazard and put in controls to prevent the damage. Now, though, it seems like people are saying, no, just because it's a psychological hazard, let's wait till someone is damaged and then deal with it, which doesn't make sense, because obviously psychological damage is more long-lasting than physical damage.
And we know
makes no sense.
And we know the psychological hazards are around these things. They're around the certainty, your certainty of exactly what you need to do. Yeah. They're around workload. They're around increase in workload, not being given enough work, being given work beneath or above what you're doing. They're around recognition and reward.
So work design.
Yeah, so it is work design. So as you change the work design for someone, these are the things you need to say. Look, when I change that work design, do I inherently increase the level of risk to the person? And if I do increase the level of risk, and this is what Bursey's saying, when I increase that level, I'm creating an inherently dangerous workplace.
Yeah.
Okay? So it's not when you're out working in a psychiatric unit in a place which has incredibly high stress and emissions. It's not just working in a prison. It's not the obvious places you think which are inherently high risk. It is as you change that work design and there is a knowledge that adheres with that a higher level of risk, there is this proactive duty to step in, identify the levels of risk that exist,
and put in suitable
controls. And one of those controls is checking in.
Yeah, but please don't think that is the only thing you need to do. Like, I think there is a common misconception with a lot of employers that says, look, I've said, how are you going? They didn't say anything, so it's fine. I've done my due diligence. But that's not the case. That's not enough.
Yeah.
And look, this is what came out through our mock court too, that, I said, are you okay? And he didn't say anything, so there was nothing more I could do.
Yeah.
And it's just not the case at all.
So let's set out what the principles of this are, because I want to nail this, because this is one of the most important safety cases this year. Psychological hazards are now understood, and they're nothing more than determining whether you do everything that is reasonably practical in respect of work design. That's it.
Yeah.
And work violence, sexual harassment, any form of aggression, those sort of things. But
work design is the big one.
Work design goes to reasonably practical.
Yeah.
So when we look at the way you work, are there psychological hazards that exist in work? When I change the manner in which I work, I necessarily create a hazard.
Yeah.
Okay. So it is a trigger point that says, okay, this is the beginning of reasonably practical. I must then determine the risk. Now, I can't do that by just staring or thinking about it. I've actually got to go
do a risk assessment.
A risk assessment. And the obligations under safety law is, when I do the risk assessment, is to consult with the affected person.
Because how else would you know?
That's right. But you notice in psychological hazards, no one does that.
Yeah.
So I say to Nina, look, I'm going to need you to work on Saturday as well.
Yeah.
And Nina looks at me and goes, no. But if I did, I'd have to say, okay, Nina, can you do this for this next 2 weeks? And what is it going to look like for you? What are things you're going to miss out on? How can we're going to have to do an assessment of whether it's viable.
Yeah,
okay?
By talking to me, not just doing it in your head, like, I've accounted for this.
So once I've determined what the risks are, then I must have a set of controls. Now, these things, like in the new Queensland Industrial Relations legislation, you better document it. And here, because certainty is such a key issue in psychological hazards, once I've had that discussion with Nina, I say, okay, this is for this period of time, this is what we're going to do, and this is how we manage it. So Nina knows how I'm going to support her, which is, I might say, I'm going to drop in and catch up with you once a week and see how we're going. Let's look at where the noise is going. I'll see if I can get a teacher's aide to come and help and take some kids away. Yep. Like, there's some obvious things that you can do about it, but the check-ins are really important. That's what Bercy and that's what Commesorov are about. And yes, they apply to common law, but this is a positive duty to intervene, and it's really nothing more than an explanation of what the safety law already requires, which is, when I place someone in a position of inherent risk by the change in the nature of work or the nature of the work itself, at that stage, I have a positive duty, not only to monitor health, but to ensure the workplace is actually safe in the beginning. So that's how they interact. So great piece of law. I'm really pleased it's come through. Great that the common law are gradually catching up with safety law, but better still for us to inform ourselves how safety law actually works. And we'll see that played out in the problem that we've got up ahead. So let's go to the problem, Nina.
Okay. Alice was offered a job with FamReach.
Yes, FamReach. I did that.
What a weird name.
I made it up.
Incorporated, a not-for-profit funded by the state government to deal with family abuse. Clients referred to them almost always women who had suffered domestic violence and sexual abuse. FamReach prided itself on diversity and embedded a quota that 40% of outreach workers must have lived experience. Alice was made an oral offer of employment. The offer was certain in respect of her hourly rate, which was around 26% above the award. She initially worked 38 hours a week. Her job was to partner with the police, ambulance, and CATT teams supporting harmed women in the north of Melbourne. She had to find them safe lodging and support networks to make them safe. There was no rotation of work. Her social work supervisor, not her work supervisor, but both were employed by FamReach, found her a calm and resilient woman. Her immediate work supervisor found her reliable, but found she struggled to read and record histories. When asked why, she said that reading the detail triggered her own trauma. Her supervisor counselled her that she must or she may lose her job. It was a core requirement of her role. Over the next few months, she took time off, worked half days, and FamReach paid her for the work she did. After a formal warning 2 months later about record keeping, they said they wouldn't offer her any more shifts as she was a casual worker.
All right. Well, look, here's the first question. If Alice brought an unfair dismissal claim saying she was a permanent employee, would she succeed given she was paid sick leave, she was on permanent roster on a full-time worker, the job she applied for was a permanent job, her flexibility of attendance was requested by her, the business permitted it, and didn't pay her any extra loading?
So you gave it away in the question.
Did I?
Yeah. There's so many indicators that she's a permanent employee.
Let's go back to the analysis, okay? Because this is personnel contracting.
Yes.
Was there an offer of employment at the time? And the answer to all of this is actually there was. So she applied for a job which was a permanent job at the time she applied for it, and it had a wage.
Yeah.
That's it.
Yeah. That's
but
clear.
if it wasn't, and the court said, oh, I'd need more, what the most recent case of O'Dwyer said, well, you'd have to actually look towards what are the post-time of offer and acceptance to determine whether they're times that would imply a contract of employment, permanent employment. And the bottom line is, so this question is really is, was she a regular or systematic casual? So that's another part. Or was she a permanent employment for the purpose of unfair dismissal? Because otherwise she would be excluded from making an unfair dismissal claim. The answer for that jurisdictional test, is she was definitely one or the other, without a doubt.
Yeah.
So she could. But more importantly, it shows how complex this gets. Okay. And it also shows, the reason I've done this question is to show how silly you get trying to analyse it, when in fact the first question is, if I offer you permanent employment and you accept it at a set rate, that has sufficient certainty at law to be the contract, so you don't have to consider all the rest of it. Yeah. So it was definitely an unfair dismissal, because they started to treat her as a casual.
Only at the end when they wanted to get rid of her.
Which bleeds into the second question, because the second question is, would Alice have successful general protections claims if she alleged she was treated adversely for requesting flexible work because of mental health, with mental health being a protected attribute in its own right, and she raised safety concerns about record keeping? But to be perfectly honest, she had a workplace right to be treated as a permanent employee. That's the first thing.
Yeah, so she was able to.
Yeah, so she was able to actually launch the general protections based on the misclassification of her employment and mistreatment. But I think the answer is,
yeah, I mean, mental health is considered a protected attribute under disability. She raised a complaint about her employment. They're clearly discriminating against her. Like, she would.
Well, that's the difficulty. So here's a person, and this cuts to one of the most complex pieces of law around discrimination, which I forgot to warn you about before we started doing this, which is, if a person can't do the inherent requirements because they suffer from a protected attribute, doesn't mean you can't terminate their employment. The issue is, can you make reasonable adjustments around it?
But they haven't even done that assessment.
No, they've done nothing. They've done nothing at all.
Be able to succeed on that.
Yeah, not at all.
You'd have to do an IME and say she wasn't fit for work.
And this is interesting, because in social work, it's very common to hire people with lived experience so that they can connect with people, which means you're taking people with previous history of mental health to look after people with mental health, and it's incredibly successful.
Really?
But the issue
is exposing them to more trauma.
Well, that's exactly the question, but that means they have lower resilience and higher levels of risk, and so the Komesarev issue comes back in and says, well, then how do I care for these people with lived experience?
Controls in place.
Okay, and I think that's dangerously into the third question, which is, would FAMREACH have safety and common law risk around psychological habits, given she obliquely raised her mental health?
I think she very clearly said that she had mental health issues and they were triggering her. So
So I think,
even before, like you said, even before she raised that, they should have had controls in place, knowing her history and having just done a risk assessment about.
I think when someone tells you, A, I have lived experience, B, reading these records triggers me and creates mental health issues for me.
It's very high
risk. And then you direct them to do it and don't find another method of doing it.
And threaten their employment at the same time.
I think you've got a lot of trouble. So that's how Komesarev will play in. And can you see now how psychological hazards, how I allocate work, how I require work to be done, is such a feature of the way the world will be under safety law in the next few years, in a way we've never looked at it before. Now, question 4, if Alice made a psychological injury workers' compensation claim after being directed to record keep, would she have been successful? So let's start again. We know that here work was triggering a mental health issue.
Yes, it's directly related to her employment.
Now, remember, there's 2 different tests in workers' compensation. She came in with a mental health issue, and therefore work has to be the substantial cause.
And exacerbated.
Yeah. So we've got that. Mm-hmm. So now that we have a valid mental health claim, the next thing is, okay, she's got it, work caused it. Was there any form of reasonable management action that sat around the record keeping? Now, it's not unreasonable to require someone to comply with a core part of a business, okay?
Yes, but also when someone raises a concern wouldn't it be requiring them to do their job with controls in place to protect them?
Well, there's two
How
parts
is
of it,
this
isn't it? So if you accept that it creates a mental health issue for the person, and that's a protected attribute, as Nina said, the next question is there an adjustment that can be made?
Yeah.
Never thought through.
Yeah.
But secondly, the idea that you can just summarily dismiss someone, because that
That's
was
not
the real
reasonable management
that's not
action.
reasonable management action anyway. Remember, reasonable management action has
Well,
two.
they gave her a warning as well, and then fired her.
That's true. But there's two fairness tests. Okay, the first one is the manner in which you're having the discussion with the person fair? Well, actually, the trigger for doing it was fair, but the manner in which it was done was not fair. And then was the disposition or the end result fair? And the answer is no. So although it was right and fair to commence the discussion, the manner in which the discussion was commenced, failing to look at the discriminatory base, make reasonable adjustments,
or do a risk assessment,
do anything at all about it, blah, gone. So the answer is she'd have a very successful claim. But the problem with this successful claim is it's unlikely she's going to come back to work. And therefore, the premium impact on this is incredibly significant. Wherever you are in Australia, if you're a 5 million remuneration business, you're looking at nothing short than 300,000 to 400,000 as a minimum premium over the life cycle of premium, up to $1 million, depending which state you're in.
Wow.
So in Victoria, in a high risk area, you could be up to as much as $1 million for that. So,
and if they had only done the risk
if
assessment,
they'd only gone back to the fundamentals, and that's, I guess, what we're here today talking about. If you go back to the fundamentals, which is someone identifies a hazard,
then you intervene.
Then you say, what is the level of risk? Okay.
Yeah.
What are the controls? Now, in discrimination law, you've got the risk. Okay. So one of the controls there is what are the adjustments you as an organisation, as a matter of law, must make so they can do the inherent requirement of the job, or can't you provide reasonable adjustments to do the inherent requirements of the job? There are no ones that could be, which would be reasonable. None of that assessment's been done here.
Yeah.
All right, Nina, that's an interesting week.
Yeah.
Challenging week. And next week, who knows what we're going to be doing? But there is, I think next week, the $2 million fine is going to be a major part of it, isn't it? The scaffolding fine that came out this week. I haven't had a chance to read the judgment to see how relevant it is. But this week we had a $2 million fine for a fall from scaffold.
I think we'll probably see a couple more slip through before the end of the year, I think.
Yeah, and our last one is on the 16th this year. So we'll see you next week.
Thanks for
Cheers.
tuning in.
Bye-bye.
Give us a thumbs up.
Yeah, thumbs up. We want thumbs up, okay?